Welcome everybody to our next presentation in the ADR Research Network Roundtable for this year. I'm John Crowe, Professor of Law at Bond University, and I'm co-convening this year's Roundtable with my colleague, Professor Rachel Field. And I'd just like to start by acknowledging the traditional custodians of the land where Bond University is located, and I believe also the land where our speaker is presenting from today, the Kombumerri people of the Yugambeh language group. We pay our collective respects to them and to their elders. Our presenter for today is Joanne Burnett, and Joanne is an accredited mental health and family violence social worker in private practice, and also a higher degree research candidate at Southern Cross University. And she's going to be talking to us today about a very important topic, which is the question of what is best practice when addressing family violence in family law mediation. So we're really looking forward to hearing what Jo has to say, and without further delay, I'm going to pass over to her.
Thanks, Jonathan, and thanks, Rachel, and certainly thanks for agreeing to read my paper as well. And just to say hello to the members of the Alternative Dispute Resolution Roundtable Network for my third opportunity of speaking at the conference on what seems to be this never-ending journey of academic writing. But I am enjoying the rewards of gaining new knowledge and better understanding, but I've got a real appreciation for the expertise and effort that's already gone into the areas of family dispute resolution. So the literature review that I'm presenting today is actually part of a bigger study. I'll just go over the study background and then the literature search, the review method, and then the findings. I first presented in 2018 at the Sunshine Coast conference, where I just had a bit of a literature review, implications for research in social work practice and family violence and family dispute resolution. I'm actually going to refer to family dispute resolution as family law mediation, just to keep it generic through the presentation. It's also in my paper, but the literature review is part of a larger study where I have been doing collecting some data on my practice as a social worker in the commercial sector of family law mediation. So the actual literature review is situated in that. I've actually got over 20 years of social work experience in different family violence settings. That's criminal courts as well as police, mental health, inpatient facilities, and as well as in the community with families, foster placements, counselling, crisis services. But when I actually started working with a commercial family law mediation service, which was in 2017, I didn't know about family law mediation or the family law context, actually working sort of in the industry. And for me, I needed to find some more evidence on social work practice addressing family violence in family law mediation, because my role there was screening for readiness for people to actually do mediation, family law mediation. So the literature review itself was led by two objectives were set, which was to have a better understanding of what were the harmful effects and disadvantages of family law mediation. And the focus of the people that we really wanted to kind of look at was women and children who were experiencing family violence. And then the second objective was to identify the practices and approaches that could actually benefit women and children experiencing family violence in family law mediation. So with these two objectives, I was looking for information on vulnerable group of people, and these people are at a really critical juncture in their lives while separating. But on top of that, they're then having to navigate a very complex and fragmented family law system. So thinking about, and there's been quite a few iterations of this literature review, it was important to find a method that could handle that kind of complex and dynamic and the messiness of that kind of information in the wider context of family law. So I kind of came to combining two methods, mainly the critical interpretive systematic process, which is actually drawn from Dixon Woods et al. In 2006, which is a critical interpretive synthesis method. It's initially it was the objectives that were set so that it was a kind of deductive process of systematic steps, you know, based on those two objectives. But then it moves on to inductive through the process of the actual steps, the systematic steps, and then the interpretive analysis, which kind of developed the question of what is best practice in and what the evidence for best practice was. Because the concept of best practice wasn't consistently defined, it wasn't operational in the field of family law. And I wasn't just searching for primary studies aimed at testing theories about what works, but through the inclusion, I kind of wanted to look at different forms of evidence. Our critical reading is fundamental as a social worker with a critical kind of approach to practice. So I was aiming to kind of generate this concept of what best practice was through this analysis of the evidence. And this meant that the actual relevance of the papers was prioritised over the methodology. So the main point of difference of combining these two methods, but mostly the critical interpretive one, was it's aligned with both a traditional systematic aggregated review of methodologies, but also interpretive configurative modes. So the aim was I was going to be looking at evidence that was drawn from empirical work, case studies, book chapters, government inquiries and reports with an explicit kind of interest with what the author's opinions or statements were and discussions in the actual publications as well. So it wasn't just about the findings. So the other part was using the JBI qualitative checklist, which was really more of a kind of, because I'm a novice at research, it was more kind of going through that checklist to make sure that I was comparing the different publications and mapping them and able to kind of understand them more easily, where there might be information that may be more empirical in one and the methods that they'd used, then there might be a commentary paper as well that might reinforce that. So it was a kind of appraisal type step. So moving on to the next. Is that the next step? Yes. So the search for so the initial preliminary search was a scoping review to capture the concepts and types of evidence. And as you can see, not really understanding the searches for literature, I managed to capture 729 papers, which was obviously unmanageable. But it did help me, I think, in looking at the breadth of and the amount of papers to narrow it down and really think through the what it was I was looking for. and why I was looking for it. So that process, although it was arduous, it was important in those ways, in those iterative ways, and helping me identify what I was looking for. So the search terms were based upon 3 topic areas, which was family dispute resolution, family violence, and social work. But I did use other terms commonly used, as like family dispute resolution and family mediation. The search parameters was English language, any type of publication that was peer reviewed, and my parameters, date parameters, were from 2006 through to 2019 for the data, the electronic database, but it was up to 2020 for the hand search publications. I included international publications that had similar family law systems to Australia. They were the States, Canada, New Zealand, and the UK. And any publications before 2006 weren't included, as they were less relevant to the topic focus. And so through this system, which I kind of managed all on EndNote, I ended up with 44 publications organised through EndNote, and I did some NVivo work as well, but that wasn't very successful. So through the JBI qualitative checklist, the main kind of role that checklist had was so the publications of those 44 publications, they were either empirical, they were either classified as empirical or commentary papers. So things like government reports, that kind of thing, were commentary, or there were papers that were purely commentary, and then papers that had original research with data collected and methods and studies were considered empirical. The book chapters, for example, were commentary also. So to understand better the kind of quality of the methodology and the extent that the publication may have addressed possible conduct and bias in study design, that kind of thing, author statements, commentary, arguments, discussions, recommendations, they were all included in kind of mapping the type of literature that I was looking at. And then I added some additional interpretive questions, which was, do the outcome measures or the conclusions focus on improving situations for disadvantaged and marginalised people? So I really honed in on that target group of vulnerable people to capture women and children experiencing family violence, and then anybody else that may sort of come into that vulnerable group. And also, is the literature based on critical realism with empirically formed inclusive practices and or findings? And critical realism is it's just a kind of heuristic to help me think more critically about the work. And again, it assumes knowledge of reality is mediated by our perceptions and beliefs. And so the information is organised into a framework representing, I guess, how different people would understand and address family violence in family law mediation. It's a kind of reflexive philosophy position to take, because the kind of knowledge that I was looking for wasn't just in findings, it was also in expertise that may have come through people's skills and competencies in the field, or stakeholder collaboration, but also authors who were able to critically examine from different perspectives. And the nature of information that I'm looking for is complex, it's problems, it's issues, disadvantages, relating to practices addressing family violence and family law mediation. And also, you know, what's commonly kind of known or practiced in the field. So the findings through that kind of analysis process of gathering all of that, mapping the literature, and then trying to capture the main themes, were what was emerging from the literature, being led by those two objectives, were influences of power, which were mainly associated with structural and professional domains. Disadvantages, which were mainly related to systemic and sociological factors, gender diversity, and then best practice. So I was really kind of funneling down and looking for best practice, either recommendations or implications or approaches, that kind of thing, and they were the ones that addressed structural, systemic and societal aspects of power and disadvantage in the literature. With under the theme of power, what was found was influence of power were found operating across the whole system, and it was found to be disproportionately impacting on women and children experiencing family violence. So there was the association of the compelling of family law mediation in terms of legislative power impacts. Perpetrator abuse of family law system in terms of systems, so that was another harmful aspect affecting women disproportionately. In the professionals domain, there was inappropriate responses towards women, disbelief, minimising of violence, advice against disclosure of family violence, and polarised perspectives on family violence. So they were your main issues around professional, the exercising of power or knowledge in those fields. And in the industry, the disclosure of family violence was actually linked with quite a lot of adverse consequences and discrimination for women, and also, of course, safety risks, with Aboriginal and Torres Strait Islander being the most at risk. And the more complex the family cases were, the more difficult it was for them to navigate the whole industry. Legislative, so conversely, one study found that in the compelling of parents for family mediation, family law mediation, there was actually opportunity to access children in family violence cases, not necessarily to have their be a part of the mediation process, but in order to check for safety and assess safety and referrals, that kind of thing. So where they perhaps might not have seen those families before, they may have access to them or engagement with them. And then there was also some positive influence in protections for women and children associated with the legislative changes in the Family Violence and Other Measures Act in 2011. So those were the main kind of themes that were coming up that were associated with power in the 44 publications. So the next theme was more around disadvantages and classed under disadvantages, but they were more associated with shared parenting culture, the 50-50 aspect of it. So there was definitely a very dominant kind of understanding that, or belief for a lot of people, that 50-50 was like the standard kind of arrangements. Another disadvantage was the state and jurisdiction inconsistencies across the publications that kept coming up, and particularly in the government inquiries, the big national government inquiries, 2019 and 2010 on family violence and family law. So they were very important to for me to be able to keep referring to and see how much of these themes were also appearing in the large reports. The multiple amendments and difficulties interpretation of legislation was also problematic and kept coming up. With regards to the professionals and industries, again, disadvantages were inadequate screening or assessments of family violence, a lack of direct questioning around family violence, poor understanding of family violence, of course, and lack of access to legal advice. There was difficulty in navigating the system with a heavier reliance on professionals, and some professionals, there was a lack of accountability to their clients. With regards to disadvantages with mediation, there was clients lacked capacity for equal and fair participation. That was quite a frequent theme or issue that was coming up under disadvantages. Mainly, of course, women experiencing family violence. There wasn't actually much information on men experiencing family violence. And research, lack of data on rates of shared care for children in family violence cases related to the prevalence of family violence cases. So more disadvantages for women, economic and psychological hardships, as well as different types of family violence that were related to gender and situations. So motivations for family violence. So in different publications, you know, initially it kind of moved from in 2006, it was moving around this idea of, you know, need for screening of family violence and the different types of family violence, right through to starting to really kind of conceptualize different types of family violence in order to perhaps look at profiling, you know, different forms, levels of family violence, in order to look at the suitability of those types of families for mediation, and whereas some may be suitable and some weren't. It was really kind of, there wasn't enough data on which ones were and which ones weren't, which accommodations would suit different family violence cases, and also whether those outcomes were sustainable. The next theme, main theme, was best practice. Of course, you know, across most of the literature, common frameworks, collaborative practice, cooperative interdisciplinary relationships, they were all kind of needed cross-industry for a much more cohesive, much more simple and easy way to navigate through the system. Legislative reform, training, clear and detailed descriptions, consistent across states, territories and jurisdictions. Consistency in family violence perspectives and training across sectors. That was quite a big one. It was very important that this consistency, in order to be able to be effective across the board, because you can't have one sort of area assessing it in one way and another area assessing it in another. So it's very important that consistency in family violence perspectives and the training is consistent across all sectors. Universal screening, I've got a question mark, because that's still, I'm not clear on whether that's still whether that is actually, it was difficult for me to tell from the publications whether, so some people did believe that universal screening was important and others didn't. So that may be down to the methods, I'm not sure. But community education and awareness was very important as well. A lot of people the information was that they didn't understand family law mediation, and most people wouldn't until they're actually in the situation. It wasn't really, you know, relevant to them. But the enhanced sort of shared understanding of family violence was important, particularly in best practice. With mediation processes, the main themes that kept recommendations or things that kept coming up was empirically tested and semi-structured screening, independent and separate assessment for both parties of family violence, adequate client preparation of legal and financial information, timely accessible legal information and support. So that was quite, you know, like that's quite important in terms of the client preparation, not necessarily needing the support all the way through, but if they didn't get that information before and have time to process and have time to include it in negotiations, it wasn't sort of that timely. Accommodations such as shuttle video and phone were important in the process, and co-facilitation and gender balance were also coming up as, again, not across all of the publications, but certainly in a few sort of publications that are dug deeper into models for family violence mediation models. I think, you know, and certainly my work in the study and the data that I've collected is that there are some women who are more empowered, who have been victims of family violence, and where safety hasn't been an issue. What's been key for them is collaborating with their knowledge of the alleged perpetrator, the type of typical behaviours, because they actually know them the best. They know them, they know the likelihood of what they're likely to do. And it particularly helped in sort of developing not just the negotiation processes, but it was quite critical in their post-separation arrangements, even things like child support agency collecting child support rather than having it privately collected, because it ties them financially to the alleged perpetrator. But also discussions around how they negotiate the distribution of finances and things like that. So these were critical aspects for some women who were no longer at risk, and the children weren't at risk, but, you know, really felt quite empowered in their discussions or their negotiations through mediation. But this usually took a fair bit of time. So when I look at some of these recommendations from the literature, they very much support the wider study that I've been doing from the other data collection. So best practice knowledge themes that were coming up with skilled family violence practitioners, trained child-focused practitioners, not necessarily child inclusive for family violence cases. Primary aggressor and accountability was quite a key aspect of knowledge, best practice knowledge. And that kind of ties in with this idea of the mediator not being neutral in family violence cases, having some knowledge of, you know, the dynamics in the case, and theoretically informed practices and approaches such as trauma-informed, critical, gendered, reflexive and child development. So they were the main theoretically informed practice approaches that were coming up. Next slide. So I'm still gathering information. I'm still kind of digging in, but knowledge that studies, future research that we're looking that were coming through the publications were ongoing longitudinal studies for screening and assessment, different types of family violence profiles, mainly for the kind of predictive factors, impacts of family violence cases on mediation processes, outcomes and agreements, and inclusion of child-focused practices with some of the future research. One of the key publications around future research was Dobinson and Gray's literature review in 2017, which was really illuminating on the current debates, divides and consensus. So I drew a fair bit of information from some publications over and above others. Family violence, like more nuanced screening, again, to kind of differentiate between the types of violence and how what accommodations might suit that in the mediation processes. And with the child focus, much more kind of awareness of who the protective parent is, capacities, the child's age, personality, in order to build in sort of protections post-separation, but also supports for all parties during the actual mediation. The gaps at this point, or the main gaps that I was finding were there was very little captured in this particular search for Aboriginal and Torres Strait Islander populations and culturally and linguistically diverse, as well as trans and gender diverse, intersex and non-heterosexual people, although I drew not on, it didn't capture it, but I did kind of draw on Dr. Olivia Rundle's paper, 2017 paper, her commentary piece on including trans and gender diverse, intersex and non-heterosexual people in family law mediation. And the other, obviously, big factor for me was there wasn't information on best practice in the commercial sector of family law mediation, which is the main sort of focus of the larger study. So the idea was in getting this knowledge from all the publications, and I hadn't realised how huge it was that best practice isn't implemented as yet. It's not consistent, it's not defined. There's no research in the commercial sector, and most of the information, or pretty much all of the information, was found in the funded sector. And in looking at that gap, is it possible that drawing on the best practice in a funded sector may be suitable for the commercial sector? And that's pretty much where I'm up to at the moment. It's still a work in progress, but at this point, they're kind of the main points that have been captured through the literature review that I've been doing. And that's it.
Thanks very much, Jo. I thought that was a really interesting and very comprehensive survey of some of the work that's been done in this area. What I think I might do is invite Rachel, if she has any comments or questions, because of course she's one of Australia's leading experts in this field.
I don't know about that, John. But thanks so much, Jo. It's so wonderful to see this kind of work being done. It's so important, and I guess one of first, just to commend you for delving into this issue, and in such, as John says, such a thorough way. And often we see people sort of canvassing the literature, but not with the kind of rigorous methodology that you're applying to your engagement with the literature. I am actually surprised that I know that you've said that the amount of information out there is huge, but I'm surprised that there's 43 things that in fact do meet your criteria as well as they have. So in a sense, that's kind of reassuring. But I would just refer you to, you would know one of our network members, Alison Boyle. She completed her PhD just recently through University of Newcastle with Tanya Sorden. And one of Alison's, the points of her thesis is that we don't have enough empirical research done on mediation. In terms of understanding the effectiveness of mediation, and Alison was looking broadly at the effectiveness of mediation and what criteria might exist for understanding whether it's effective or not. But you're sort of focusing in on what's effective in this particular context. So I think that some of what Alison might have said in her thesis could be helpful in terms of thinking about when you're talking about what we need for future research and so on. I think some of Alison's suggestions about the need for more rigorous approaches to really investigating what's happening in mediation, and of course the confidentiality of the process is the thing that gets in the way, doesn't it? So often. So I did want to, there's so many things to talk about, aren't there? And I know I can't hog all the time. One of the things, I've just come back from a symposium in Toowoomba with the Family Relationship Centre there, and one of the things we were talking about, which I think is really relevant to the efficacy of family mediation or FDR in Australia, is the notion of legally assisted. So I saw that come up a little bit in what your findings were, but I wondered whether you'd like to respond to that overall importance of having a legally assisted model, along with perhaps a co-mediation model where there's gender balance, but focusing particularly on that issue of legally assisted, how that has come out of your investigation of the literature.
That's been so there was some international publications that talked about the need for that, or that they found that was helpful in best practice, and the obviously your publication around that legally assisted, but there was definitely, it kept coming up, including in some of the larger reports, that there was a need for accessing legal information. Again, this is around family law mediation, having an understanding of the parameters of family law in the cases of negotiation. So there's a kind of benchmark of what people are negotiating. And I think in particular where with family violence cases, there's a tendency or potential for, a lot of kind of uncooperative participants who will bluff or who will threaten. Right, well, this is court, and for people to understand, whether it's women or men, it is irrelevant, where they're disempowered, where they lack knowledge, where they lack information about their finances, but particularly where there is high coercive control, the power of the perpetrator to still influence behind the scenes and sort of, for the victim to understand that if it were to go to court, what more likely a judge might interpret that information as, or determinations. So there's this balance of being totally influenced by what the perpetrator's been saying versus this some balance of, well, hang on, this is what's more reasonable coming from legal practitioners.
And one of the things that I was thinking when you were talking about the culture that's been created by the legislation in terms of that shared parenting pro-contact culture, I was thinking that if we look strictly speaking at the legislation, that it doesn't have to be in the legislation, that culture. It's actually a creation of the court and the profession. And it is a result in many instances, I think, of professionals in the field not understanding the complexity of the legislation because of the way that it's been drafted. And they feel that it's taking them in a specific direction when, in fact, if you studied it carefully and unpacked it properly, you would see that it's not as cut and dried as 50-50 parenting, as some people will say. So I think that's a problem too, isn't it? When you're highlighting the importance of a legally assisted model, and yet you can't rely on the legal profession to be fully understanding of the legislation because it's been drafted in such a way as to confuse everybody.
Yeah, and anecdotally, working in this field specifically, well, in the commercial sector, but also working a lot with victims of crime, predominantly women who are going through family law processes. This has been one of the most common threats or beliefs that they have, and you can kind of talk to you blue in the face and say, well, it's not actually necessarily the case, but it's very difficult to shift that when it's been so sort of ingrained for so long.
Yeah, exactly. So I understand that you've chosen to use the word family law mediation instead of FDR, which is what's in the legislation. So I'm sure your examiners will want to be knowing why you chose to do that. So I thought I'd ask that question. What's the justification for that?
Yeah, the main reason around that was because I wanted to take away this the old kind of culture of family dispute resolution, but particularly because I was working in the commercial sector, I wanted to make it easy, understandable to not just people who work in the industry, but also anybody, so they understand what family law is and they understand what mediation is in that context. But not everybody knew what family dispute resolution was, or had heard of that. So, and the other thing is it's highly associated with the funded sector.
Yeah. So that's an interesting question. I mean, in terms of identifying best or good practice, and I noticed that you're using good practice in your abstract, but best practice in your presentation. And, we could argue about those words, but we won't. I just wondered whether there is a massive difference in the fact that, people are paying for it as opposed to not paying for it. Are the criteria for effectively dealing with the dynamic of DV in family law mediation, are they the same? Or does the fact that they're paying for it really make such a big difference?
Yeah, well, there is so I know it's difficult because the literature review has, I've kind of dug in more since I've already collected the data from the larger study, or the other, the study that it's located in. I already know that there are major differences and dynamics at play that don't apply to the funded sector, which makes it tricky to actually bridge some of those best practices across. So yeah, this is kind of partly why I went back into the literature to sort of look for specific aspects that and one of them is this idea of universal screening, because if you apply it only in one sector, like the funded sector, and then you don't apply it in the commercial sector, then they get to choose which mediation they go through, and they don't necessarily have to do thorough screening. So the inconsistency aspect of it means that often for vulnerable women, they're still going to be influenced. They'll still be influenced by the perpetrator who decides to go somewhere else because there's no screening or less screening or less adequate screening. So
okay,
yeah, these were I know it's kind of crosses over, but I'm just trying to stay as pure to gathering the information that was in the publications and pick up on some of those aspects as well.
I better let you have a go, John, because I'm hogging the question and discussion time.
Well, unfortunately, I think we might have to wrap things up there for reasons of time. But can we just conclude by thanking you once again, Jo, for sharing your thoughts with us today, and also, of course, with the other members of the ADR Research Network who will be viewing this presentation through the blog and online. And hopefully we'll have an ongoing discussion about these topics in that forum. So thank you very much.
Thank you, Jo.
Thank you. Thank you. Thanks, John. Thanks, Rachel. Bye-bye.